In this video, we will be looking at the sample questions of legal aptitude. We already have put 4 videos. Please make sure you watch those videos, and this is the 5th in the series. So this is some of the kind of questions which you can get in the CSEET exam. I am CS Alok, and let us discuss these questions. The transfer of power to the Indians and partition of the country was laid down in dash. Cabinet Mission Plan, Simon Commission, Cripps Mission and Mountbatten Plan. So here you need to remember that the answer is Mountbatten Plan. And let us say, even if you don't know the answer, during the time of independence, Mountbatten was the main person who was involved. That is what we know from history. So when we look at this, the 3rd June Plan is also called as the Mountbatten Plan. So what happened here? The British government, they proposed a plan, and this is the concept of partition of India. What was called as British India, that was going to be partitioned, and we all know that later it became partitioned as India and Pakistan, right? It was declared that Pakistan will be an Islamic country and India will be the country for Hindus. Of course, later India became secular. We also know that in 1976 we had the mini constitution, or the amendment which we call as mini constitution. That time we adopted the word secular. So the plan to transfer powers to Indians and partition of the country was laid down in the Mountbatten Plan. That is the first one. Next, who among the following have been given rights to legislate on residuary subjects? State government, central government, or both state and center and president? The answer is central government. Let us have a look at it. So we have, broadly you need to understand something. So we have 3 lists in the constitution. Those lists are what? Union list, state list and concurrent list. What are these lists? These lists have different items of business about who can make the law. So if there is something in union list, only the union government can make the law. If there is something in state list, only state government can make the law. And in concurrent list, both union and center, both union and the state, union and the state can make the law. So now what about this residuary powers? So here we need to understand Article 248. Before that, what is this residuary powers? We call it as reserved power, residual power or residuary powers. These are nothing but powers which are neither prohibited or explicitly given by law to any organ of government. Okay, so such power as well as general power of competence are given because it is impractical to detail in legislation every act allowed to be carried out by the state. So when we can't give exactly about whether it is union, state or concurrent, there are some residuary powers. So and in India we have Article 248 that says that Parliament has the exclusive power to make any law with respect to matters which is not there in list 2 and list 3. What is list 2? We have state list. List 3, that is concurrent list. So residuary powers, so such power shall include the power of making of any law imposing a tax not mentioned in either of those 2 lists. Entry 97 of the Union list also lays down that Parliament has exclusive power to make laws with respect matters not enumerated in list number 2 and 3. So this is list number 1 Union, list number 2 state, list number 3 concurrent. Now let us say that overall, just for example, let's say that there are 100 things. Let us say Union list has 40 things, then state list has another 30 things. Okay, then concurrent list has, let's say, 25 things. So 40 plus 30 plus 25 is 95. So there are 5 more things which is not there in state or concurrent list, nor is it in union list. That is only residuary matters. So for these residuary matters, the question is, who have been given the rights to legislate? Legislate means to make law, to make the law, or what we call as act, ordinance. Who can legislate? Who can frame the law? Who can frame the law on residuary subjects? So what are the residuary subjects? For example, just for example, I told if there are 100 items or 100 subjects, 40 are already given in list 1, 30 in list 2, then 25 in list 3. So 95 will be the thing. So if the 5 things are what we call as residuary subjects or residuary matters. So these things, who may frame the law? So if you just read the list, you won't know, because here it is 40, 30, 25, but we don't know who has to do for this. So the answer is very clear. It is given that union list, the entry 97, that Parliament has the exclusive power to make the laws. So when we say Parliament, it means central government. Hope you are getting it. Okay, so now who among the following have given the rights? So the answer will say is central government. Then question number 3. Which article of Constitution provides guidelines for amending the preamble? So the answer is Article 368. Again, it is a memory test, but let's see what is 368. So the Constitution of India, Article 368, grants constituent power to make formal amendments. So whenever you want to make a amendment to the Constitution, for example, we had the GST amendment, correct? So it empowers Parliament to amend Constitution by adding or variation or repeal of any provisions according to the procedure laid down therein, which is different from the procedure for ordinary legislation. So for ordinary legislation, it's different, but if you want to amend the Constitution, you need to look at Article 368. So what is the question? Which article provides guidelines for amending the preamble? So preamble is part of Constitution of India, correct? So if you want to amend the preamble, then you have to look at Article 368. So that is the question. So this is how you should analyze the questions, and then you'll know how to tackle MCQ. See, when you analyze like this during studies, your exam will become easy. Question number 4. In a standardized contract, what is the concept? Individual has no choice but to accept and sign the dotted line. The individual must be protected in contract. The agreement is without consideration, none of the above. So definitely this is not the answer. Agreement is without consideration. Then none of the above is not the answer here. The individual must be protected in contract. We have to say that yes, this is possible, but the individual has no choice but to accept the dotted line. So this is the correct answer. Why? In standardized contract, as the name goes, it is standard. So let's analyze it. What is a standard contract? So when we have any contract for that matter, okay, it's basically agreement where 2 or more parties who are competent to contract, they have meeting of 2 minds, correct? And they have consideration, they have consent, all this we have, and then they agreed on something, whatever it could be. It could be buying and selling, it could be service, whatever it is. So in a standard contract, what happens is, the example is software licenses. So have you seen, when you're using any software, even on your computer or laptop, there will be some terms and conditions. Even for that matter in Facebook, Instagram, when you first join, do you agree terms and condition? You would have said yes actually. Without your knowledge, you would have clicked it. We call it as click wrap agreements. So here there is no concept of negotiating, because one party is asking, do you agree? There'll be a button, correct? You have to click on that. You have to click on that button, and then you are agreeing to the standard contract. Now what if you don't like some terms? You can say disagree, and that time you cannot use that software or like computer software license or anything. I just gave you example of computer because all of you would have definitely you have entered into a standard contract. Without your knowledge, you would have entered into a standard contract sometime, even if you are just using Facebook or Instagram or YouTube, or even if you open a simple Gmail account. When you open a simple Gmail account, you would have actually entered into a standard contract where you would have actually just signed on the dotted line. So online you can't sign, so you would have clicked the button agree. So there is nothing. If you don't agree, don't enter the contract. So you're not. So just because some student told, sir, then it is something like forcing. No, sir, it is coercion. Coercion to enter contract. There is no scope for negotiation. No, it's not like that. See, you are given a choice. You will have two buttons: agree, disagree. Okay. So if you read the standard contract completely, it will be a lot of pages will be there. If you don't agree, you just click this. So you don't have to enter the contract. If you agree, then you can sign on the dotted line or you can accept it. Okay. Next, again related to contracts. The correct sequence in formation of contract is dash. Offer, acceptance, agreement, consideration, first option. Then we have agreement, consideration, offer, acceptance. Offer, consideration, acceptance, agreement. Then offer, acceptance, consideration, agreement. So we know that first thing offer should come. So this cannot be the answer. The second thing acceptance should come. So this also cannot be the answer. Correct? So we have offer, acceptance in the first one. So after, then there's this consideration concept. But please remember, first we should agree what is the consideration. What is each one giving the other party. So even this cannot be the answer. So obviously the answer will be D. First there is offer. A has offered something to B. Then the B has accepted it. Consideration. So A is giving money to B and B is giving the service or product to A. Consideration. That time they have an agreement. So this is the sequence. So this is how you should analyze. Then we come to the last question. Unliquidated damages means. So this is coming in torts. Even in contracts, little concepts you have this. So what is it? Damage to something solid. This is wrong. It is not about solid and liquid. So it is the wrong answer. Damage caused by a firm which has gone in liquidation. No. Damage to a firm in the hands of receivers. Let us see. Damage to be assessed by a court, as these are not predetermined. So the answer is D. So unliquidated damages, what is the two things we need to know? First we need to know liquidated damages and unliquidated. So usually this unliquidated damages comes in torts and liquidated damages usually come in contracts. So doesn't mean that you can't have unliquidated damages in contracts. You can, but I'm telling usually. I'm just telling usually what happens. So let us understand one thing very clearly. In liquidated damages, there is a clear condition. Okay, for example, A tells B, on 5th of October, you have to supply me 10 chairs. If you don't supply, you have to give me damages worth rupees 50,000, because A needs it on 5th October and B has agreed. What he agreed, 5th October I'll give 10 chairs, and if I don't give, I'll give you 50,000 damages. So B has to give 50,000 to A if he doesn't supply the 10 chairs on 5th October. So now 5th October B will default. So what will happen? There is a breach and then there is liquidated damages, that is damages which is already agreed. So damage is already agreed, so he has to pay 50,000. But in unliquidated damages, there is no precondition. There is no precondition on damages. So how much damage should be given? Court decides. Court means judge. Court decides damages in unliquidated damages. So what is the question? Unliquidated damages means damage to be assessed by a court as these are not predetermined. See, in the example I told you, in this they had predetermined. What is that? 5th October, if you don't give me damages 50,000. So it is agreed, it is predetermined. But in unliquidated it is not predetermined. So this is the sample questions. So we have covered all the 6 questions in this video. Please watch the previous 4 videos and watch this 5th video. We'll also make more videos on the sample questions for legal aptitude.